As the Trump administration begins, business leaders should anticipate significant shifts in the labor and employment legal and regulatory landscape. Deregulation is expected to take center stage. Policies simplifying and removing employer obligations are likely to go into effect. Here's what to look out for. President Trump signed an executive order directing agencies to combat DEI initiatives in the private sector. The order instructs the Attorney General to work with federal agencies to submit a report with recommendations for ways to encourage private sector employers to end their DEI programs. Each agency also would be required to identify up to 9 potential DEI-related civil compliance investigations of certain organizations. Private employers can therefore expect more scrutiny of their own DEI initiatives as the administration seeks to limit race-based and equity-focused workplace policies and programs. This could lead to increased challenges in balancing compliance with internal DEI goals, and some organizations may face legal risks if their programs are perceived as discriminatory or in violation of merit-based principles. Therefore, businesses will need to reassess their DEI strategies to ensure alignment with changing regulatory expectations while maintaining workforce hiring, promotion, and retention objectives. Immigration laws could tighten under the new administration, with a focus on more rigorous enforcement of hiring practices and changes to visa programs. President Trump has signed a series of executive orders aimed at strengthening immigration enforcement. These include measures to limit access to certain visa categories and measures that may impact worker eligibility verification. As a result, businesses that rely on foreign labor should consider whether to adjust their workforce planning and recruitment strategies, as the availability of skilled international workers could decrease, and the compliance burden for companies hiring from abroad may increase. Still, Trump has publicly expressed support for the H-1B visa program, so it remains to be seen the extent to which his administration restricts visa programs. During the Biden administration, the Department of Labor issued a rule that made it more difficult to classify workers as independent contractors than a rule from the first Trump administration had. It is unclear whether Trump, in his pick for Secretary of Labor, who is considered more employee-friendly than many observers expected Trump's pick for the position to be, plan to roll back the rule, and if so, whether they'd revert to their previous standard or some other standard. Regardless of what happens at the federal level, companies will still have to ensure compliance with applicable state law as well. The Senate's recent rejection of President Biden's National Labor Relations Board nominee has prevented a Democratic majority on the board and makes it likely that the board will have a Republican majority that would potentially lead to more employer-friendly decisions. Businesses should remain proactive, monitor regulatory updates closely, and prepare to adjust HR practices to stay compliant with the evolving labor and workplace rules of this new administration. Feel free to contact a member of our team with any questions about these orders. To stay up to date with the latest developments, continue to follow our Labor Speaks and Policy Pulses, as well as Aiken's Executive Order Tracker.